Hello and welcome to Unacademy. For the first time in the history of independent India, a notice has been submitted in both houses of the Indian Parliament for the removal of the Chief Election Commissioner. Two important things. Number one, it is not impeachment. Impeachment is a term used only for the President of India, it is removal. Second, the Chief Election Commissioner, Mr. Gyanesh Kumar, may survive. He may not be removed. Why? Because the opposition lacks numbers to get this motion passed in both houses of the Indian Parliament. But in this video, let's discuss all the important details that you need to know from this particular topic. But first up, Article 324 of the Indian Constitution. It creates a constitutional body called Election Commission of India. And the job of the Election Commission of India is to hold and conduct elections, be it Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council, President's election, Vice President's election. Constitution says superintendence, direction, conduct, control of all the elections is vested in this body known as the Election Commission of India. Constitution further says that this Election Commission of India shall comprise of Chief Election Commissioner and as many election commissioners as may be appointed by the President. Initially, the Election Commission of India was a single member body. We only had a Chief Election Commissioner. Election commissioners were not appointed. Then initially in the late 1980s, then in 1991, more election commissioners were appointed. Two election commissioners were appointed. Matter went to the court. T.N. Session, we Election Commission of India, the year was 1996. Long story short, the question before the court was, are these election commissioners appointed to curtail the powers of the Chief Election Commissioner? Why should there be a multi-member Election Commission of India? But Supreme Court ruled in favor of the executive and said, look at what is mentioned in the Constitution. Election Commission of India shall consist of Chief Election Commissioner and as many election commissioners as may be appointed by the President. So this is the executive decision that needs to be taken. But further, Constitution further said how these election commissioners, how the Chief Election Commissioner shall be appointed. For that, there has to be a law enacted by the Parliament. But this law was not enacted by the Parliament for decades. Matter went to the court. Anu Baranwal v. Union of India 2023. There were two major questions that the Supreme Court had to answer. Number one, does the current process for ECI appointments violate the right to equality under Article 14 of the Constitution? Number two, does the current process for ECI appointments violate the right to free and fair elections, which is part of the basic structure? Because Election Commission, the appointment of the Chief Election Commissioner and election commissioners was done by the President based on the advice of the government, based on the advice of the party in power, which basically means it may be arbitrary. When it is arbitrary, it violates Article 14, it violates free and fair elections because the party in power will have their own men appointed to this body whose job is to organize free and fair elections. How can this body organize free and fair elections if the appointment to this body is made by the party in power, advising the President of India? Supreme Court said, yes, this is violative of Article 14. This violates free and fair elections. That is why till the time Parliament enacts a law, this appointment will be done by the President based on the recommendations of a committee. And this committee will have Prime Minister, Chief Justice of India, and leader of the opposition in the Lok Sabha. So this body, this committee will meet and together they will advise the President who is going to be the Chief Election Commissioner, who is going to be the Election Commissioner. But then a law which was not passed for decades, Because Constitution says there shall be chief election commissioner and as many election commissioners as may be appointed by the president. But how they will be appointed, for that there needs to be a law. This law was not enacted for decades. But once Supreme Court gave this verdict in 2023, in no time the law was enacted. And what did that law say? Before we discuss that law, here is an announcement on your screen. We have reduced the subscription fee for our UPSC preparation programs by more than 60%. And we are also giving double validity, which means if you subscribe to our course for 1 year, you will get 1 year extra validity without any additional cost. And this is done to commemorate the success of Unacademy students in CSE 2025. And right now, our plus subscription is available at 16,999. Use this opportunity because this offer may end very soon. Use this opportunity, use this code IS English, subscribe to our courses, and let's study together and ace this examination. Let's come back to the lecture. The law was enacted. CEC and other election commissioners, Appointment, Conditions of Service, and Term of Office Act 2023. Now, according to this law, now the president will appoint chief election commissioner and the election commissioners, but this time on the basis of a committee. This committee will have Prime Minister, Leader of the Opposition in the Lok Sabha, and a Union Minister nominated by the Prime Minister. So basically, CJI will be replaced by a Union Minister who is nominated by the Prime Minister. Does this also not mean that it is arbitrary? Because again, the executive has the complete say in the appointment of the CEC and the election commissioners. The party in power will have the complete say because the law says even if there is a vacancy in this committee, let's suppose there is no leader of the opposition, even then Prime Minister and the Union Minister together will recommend the president who is going to be the next chief election commissioner, who is going to be the election commissioner. This would violate free and fair elections. This sounds arbitrary and as such violative of Article 14. This law was also challenged before the court. And this matter is currently pending before the Supreme Court. But after that, what we saw some controversies. Controversies, the incumbent chief election commissioner, Mr. Gyanesh Kumar, he has made some controversial statements. For example, the footage inside the polling booth, we will not share it. Why? Because how can we share the footage? Because our daughters, our sisters, they come inside the polling booth to exercise their right to vote. How can we share this footage with anyone? But the same election commissioner, the same election commission, when it organized the president, the vice president's election, the footage was shared, even when the women MPs voted. And he has made some controversial remarks. And special intensive revision of electoral rolls conducted first in Bihar and then various other states. West Bengal, there has been criticism against the chief election commissioner that he is acting in a biased partisan manner. A delegation of the Trinamool Congress met the chief election commissioner and Trinamool Congress is saying we may release the transcripts of that meeting and he has humiliated us. Long story short, the allegation against the chief election commissioner is that he is towing the line of the ruling party at the center. He is aiding the ruling political party and he is not in any way ensuring free and fair elections in India. But how can the CEC be removed? The CEC is removed just like the judge of the Supreme Court. And election commissioners are removed only upon the recommendation of the CEC. Listen to me carefully. Here is the chief election commissioner and there are election commissioners. Chief election commissioner will be removed in the same manner and on the same grounds as the judge of the Supreme Court. Which means who can remove the chief election commissioner? President. Based on the resolution passed by both houses of the Indian Parliament by special majority. That too on what grounds? proved misbehavior or incapacity. But when it comes to the election commissioners are removed by the president, but only on the recommendation of the CEC. This is meant to protect election commissioners because otherwise the government could have removed election commissioners. So, to protect the independence of the election commissioners, an election commissioner cannot be removed unless and until it is recommended by the CEC. But there is also a criticism that these election commissioners may come under the influence of the chief election commissioner. It is meant to be a constitutional body. The powers of the chief election commissioner and election commissioners, they are same. They have equal powers, equal role, equal responsibility. So we should have a mechanism where election commissioners also should be removed in the same manner as the CEC is removed, which means as the judge of the Supreme Court. That is one reform that is suggested, but this reform has not been implemented. But if the CEC will be removed in the same manner and on the like grounds as the judge of the Supreme Court, how is the judge of the Supreme Court removed? Based on the order of the president, on the basis of the resolution passed in both houses of the parliament by special majority. And what is that special majority? Two-thirds of the members present and voting and majority of the total membership of the house. On what grounds? Misbehavior or incapacity. But Constitution does not define what is misbehavior, what is incapacity. Constitution does not define the process that you need to follow to remove the judge of the Supreme Court. That process is mentioned where? In a law enacted by the Parliament known as the Judges Inquiry Act 1968. According to this law, there has to be an investigation by a committee. Because if you are alleging that a particular judge or the chief election commissioner, he is accused of misbehavior or incapacity, we need to investigate. And that investigation will be done by a committee. But this committee can be formed only after the presiding officer accepts this notice. If this notice is issued, introduced in Lok Sabha, 100 MPs should sign this notice. If this notice is introduced in the Rajya Sabha, 50 MPs should sign this notice. And if it is introduced in Lok Sabha, then Lok Sabha Speaker has a discretion. He may or may not accept this motion, which means maybe in all likelihood, the Speaker of the Lok Sabha may not accept this notice calling for the removal of the CEC. If this notice is introduced in the Rajya Sabha, 50 MPs will have to sign this notice, but the chairman, the Vice President of India, may or may not accept this notice. Just like what happened in 2017, when the Chief Justice of India, Justice Deepak Misra, was sought to be removed by the opposition. Notice was introduced in the Rajya Sabha, but the chairman of the Rajya Sabha did not accept this notice. So this means that the presiding officer, the speaker, or the chairman, they have a discretion. But this is when, listen to me carefully, very important for prelims. This is when you introduce notice in Rajya Sabha, chairman has a discretion. You introduce notice in Lok Sabha, the speaker has a discretion. What if you introduce notice in both the houses on the same day? Then this committee will have to be constituted both by the chairman and the speaker jointly. So this committee, which will have one judge from the Supreme Court, one chief justice from the High Court, one eminent jurist, this committee will have to be constituted jointly by the Speaker of the Lok Sabha and the Chairman of the Rajya Sabha. And then this committee will investigate and ultimately submit report to the Parliament. If this committee says no, the allegations of misbehavior and incapacity are untrue, we could not prove these allegations, then Parliament cannot proceed further and remove the CEC. But if this committee says, yes, we have proven these allegations, even then Parliament may or may not proceed with this report. But if Parliament decides to proceed, then you need to pass this resolution in both houses of the Indian Parliament by special majority. And once it is passed, it is sent to the President. and it becomes a statutory resolution. A statutory resolution is binding on the president, which means if both houses of the parliament pass this resolution, it is binding on the president to issue an order and remove the CEC. To recap, long story short, we have the CEC, Mr. Gyanesh Kumar. Can he be removed? Yes. By whom? By the president. Based on the resolution passed by both houses of the parliament by special majority. And this resolution is binding on the president. But on what basis can the CEC be removed? In the same manner and on the like grounds as the judge of the Supreme Court, which means on the grounds of proved misbehavior or incapacity. For that, a committee has to be constituted, which will investigate and inquire into the allegations against the CEC. Who will set up this committee? If this notice has been introduced and admitted in Rajya Sabha, then the chairman of the Rajya Sabha. If this notice has been introduced and admitted in Lok Sabha, then the Speaker of the Lok Sabha. But if it is introduced and admitted in both the houses on the same day, then this three-member committee will have to be constituted by the Speaker and the Chairman together. This is how the CEC can be removed. But I also told you that maybe the CEC will not be removed. Why? Because the opposition lacks numbers to remove the CEC. But what we need an independent, non-partisan, a fair body known as the Election Commission of India. As they say, justice should not only be done, it should be seen to be done. The conduct of the Election Commission has to appear that it is fair, it is not partisan. For that, the biggest reform can be change the law, amend the law, which is used to appoint the CEC and the election commissioners. Make this law transparent. In the sense, let's bring back the CJI. Let this three-member committee be headed by the Prime Minister, who represents the executive. Chief Justice of India representing the judiciary. A leader of the opposition representing the legislature. So executive, legislature, judiciary together should come and discuss names and advise the president. Who should be the CEC and election commissioners? I will go a step further. Have two members from the civil society as well, so that these members from the civil society can also be part of this body to advise the president who is going to be the next CEC and the election commissioner. There are some who say, let's go a step further. Let's also have the nominees of two major national political parties, apart from the parties which are already represented by the Prime Minister and the leader of the opposition. Let's have two leaders of two national political parties also part of this consultation exercise, so that the entire nation will know that this CEC and these election commissioners who have been appointed, they have been appointed basis on the consensus amongst the political class, executive, legislature, judiciary, civil society, political parties. That's how we can strengthen this institution. What are your suggestions? How can we reform this body? Do let me know in the comment section, and do not forget to subscribe to our YouTube channel. Thank you for watching. Goodbye.